everyone. Welcome to our panel on serving crossover youth during COVID-19 and beyond. If all the panelists could please turn on their videos, we're going to get started. So first of all, I'd like to introduce myself. I'll be your moderator. I'm Megan Stanton-Trehan, and I use she, her pronouns. I'm the director of the Youth Justice Education Clinic here at Loyola Law School and the Center for Juvenile Law and Policy. I'd like to start off by just thanking Rose Hills for their generous support of our work during COVID-19 to serve crossover youth and at-risk youth in LA County. So if we could all start by introducing ourselves here today, please give your name, pronouns, organization. And I'll go ahead and start with Brooke.
Good morning, everyone. My name is Brooke Harris. I'm the managing attorney at the Juvenile Justice Clinic here at Loyola, here being, operative as these things go. I use she, her pronouns.
Vivian?
Good morning, everyone. My name is Vivian Wong. I use she, her pronouns, and I'm a staff attorney and adjunct professor at the Youth Justice Education Clinic, which is part of the Center for Juvenile Law and Policy at Loyola Law School. We provide special education advocacy, school discipline defense, regional center advocacy for our young people who are involved in the juvenile injustice and foster care systems. We also engage in policy and coalition work on youth justice and education issues.
Thanks, Vivian. Victor?
Hey, good morning, everyone. It's an honor to be here. Thanks for the invitation. My name is Victor Leung, pronouns he, him, his. I am the Director of Education Equity and the Deputy Litigation Director for the ACLU of Southern California. The ACLU handles a lot of different things, but here in California, we really focus on education equity, which means we focus on ending the school-to-prison pipeline and providing traditionally under-resourced students with the best possible education.
Alaina?
Hello, everyone. Thank you for the opportunity to be here. I'm Alaina Moonves-Leb, she, her pronouns. I am a senior staff attorney at the Alliance for Children's Rights. The Alliance is a legal services nonprofit that advocates for children, young adults, and families impacted by the foster care and delinquency systems, helping them access the support and services they need. I'm part of our education program, and in our work, we represent youth with respect to all their education needs, including general education supports like enrollment, graduation, as well as special education rights. And we also do some policy work around these same issues.
And Eva.
Good morning, everyone. My name's Eva Grenier. I'm an attorney at the Children's Law Center of California. I'm in the CARE unit, which stands for Crossover Advocacy and Resource Efforts. So our focus there is on dual status youth and securing the best outcomes for young people in coordinating between the dependency and delinquency systems. CLC represents all foster youth in Los Angeles County in their dependency proceedings. And I also am a former fellow of the Juvenile Justice Clinic, where I represented foster youth and youth in delinquency court.
And Betty.
Good morning, everyone. My name is Betty Fang. I use she, her pronouns, and I'm a policy associate in education and justice at the Children's Defense Fund, California. CDF California is the state office of the Children's Defense Fund, a national child advocacy organization founded by Marin Wright Edelman to ensure a level playing field for all children. As part of the education policy team, our vision is to transform school culture, practice, and funding to ensure underserved students and families receive high quality education services. And we have a specific focus on students of color, students who are overcriminalized, and special education, English learner, and foster youth students. Our practice and values are grounded in racial justice, education being a human right, and working with those most impacted and building our power together. So we document community experiences and feedback, partner with students, families, and grassroots organizations to conduct policy, data, and budget analysis.
Thank you, panelists. So I just wanted to also start by noting if anybody has a question during this presentation, go ahead and type it into the Q&A box, and we will either answer it as it comes up in what the panelists are speaking about, or at the end during the question and answer period. So I'm going to get started with our first question. Let's see, what were your organization's initial responses to advocacy during the unprecedented crisis that is COVID-19? We can go ahead and get started with talking about direct services. So we can start with Brooke and then go to Eva, Vivian, and Alaina.
Thanks, Megan. So our response was immediate. We saw the crisis looming, right, as we all sort of did at the end of February and early March, and started thinking about what we could do. Sam Buckingham had a client who had been rearrested, and Megan and Sam and the team worked diligently and quickly to get him released in anticipation of a huge outbreak and a shutting down of society, which ultimately ended up happening. As part of that, there was a motion for release that directly addressed COVID-19 that was shared with advocates across the state, added to the Pacific Juvenile Defender Center, who we partner with and who works with juvenile defenders across California, got declarations from children's doctors, children's psychologists, and we at the CJLP filed motions on behalf of every detained child that we had. We had kids facing transfer. We filed motions to get them released based upon COVID-19 and a lack of education, a lack of connection from family. It was so severe what happened to these kids when COVID-19 hit. They were stuck in juvenile hall, stuck in camps. There was no school for a while. There were no teachers coming in. Mental health services stopped. Family visits stopped on March 12th. And kids did not see their families for months on end. Frankly, the juvenile hall was slow to set up video conferencing, and it was an incredible period of isolation for our kids. So we filed for all of our detained youth at least 2 motions for release and had an oral argument. If the first motion didn't work, we tried again in a couple of weeks as the crisis was continuing to unfold, and we got updated declarations again from experts. But we fought hard to get Everychild released and to work with other defenders in LA and across the state to pool resources, to pool ideas, to pool motions, to just try to reduce the populations of detention facilities so that kids could be with their families. They could, imagine being a teenager. We were all so unnerved and at home all of a sudden. Imagine being a teenager alone, away from your family, locked up when this pandemic struck. It was pretty awful.
Thanks, Brooke. So I'm going to also add to that there was also efforts to file 778 motions around terminating probation. So the extensions of court hearings, having a young person who, let's say, had a 6-month progress report suddenly be extended 3 months, and there was no need to have probation continue. We also filed motions to terminate probation in those instances, and similarly use the delays in court hearings as advocacy points for pre-adjudication youth in negotiations and in requests for diversion from the court. So on the CLC care side, our unit also took efforts to identify all detained young people, all our detained dual status youth in camps, halls, and Dorothy Kirby. Our attorneys worked hand in hand with defense counsel to come up with 778 arguments and approaches to requesting release. We worked and coordinated with DCFS to identify relative placements and other STRTP or safe and appropriate placements for our youth. And we fought hard side by side with defense counsel to get young people released. Once released, we also organizationally, for both our dual status youth and all foster youth, we had an initiative to get young people access to Chromebooks and tablets so that remote school, remote therapy, and our remote case management and investigators could actually connect with our young people in the community. Obviously, we all know that was a major barrier, and that took a lot of logistics and a lot of one-on-one work, but the pandemic absolutely affected our youth, and the stop in visitations with family members, both for young people in detention and young people in the community, was a major, had a major impact, obviously, on their relationships with family. So for young people who are receiving reunification services, to not have contact with biological family members or legal guardians had a real negative effect. So we also advocated with the court to be flexible around probation conditions. So CLC 100% collaborated with defense attorneys for these same goals of keeping our youth safe and healthy, and ideally out of detention.
Thanks, Eva. Yeah, so looking back to a year ago, it's really when schools officially started to close down their brick and mortar buildings. And so when schools decided to close down, there was a period where a lot of students weren't getting any instruction at all. And so it was kind of like the wild, wild west. You know, our community has never experienced such a widespread school closure like that. And so you know, what we did was we requested IEPs for pretty much all of our clients. The IEP meeting is really the vehicle to understand what's happening in a student's education if they have a disability and qualify for an individualized education plan. And so we found out that a lot of school districts weren't even holding IEP meetings for several weeks in the beginning. And then once they finally started to have IEP meetings, we tried to craft IEP meetings with virtual instruction in mind. So we really try to get to the granular understanding what virtual instruction would look like, how would their services be implemented, and quite honestly, I don't think, you know, school districts had an understanding of how to implement IEP services in the very beginning. And so a lot of our students went without full implementation of their IEP services, and a lot of them were not receiving any education at all. For our students who were detained, they were relegated to independent packet work for several months while they were still working on developing a virtual platform that met their privacy concerns. And so for the students who were receiving independent packet work, they were struggling with that. The packet work is not individualized to their unique needs, it's static. And what's worse is that once they complete the packet, they aren't able to have immediate assistance either from a qualified teacher. And so if, I've had a client who wrote, "I don't understand this." It wasn't tailored to that student's unique needs given his disabilities. And by the time he actually received help, which was several days later, he couldn't even remember what he needed help on. So it really was a challenge at the time to advocate for appropriate distance learning in the very beginning. And that is really what led us to create, alongside public counsel, these work groups focused on education advocacy in light of the school closures. And so we developed work groups on IEP advocacy, due process, school discipline, statewide advocacy, and federal advocacy, just to brainstorm with our community partners about what's happening here and how can we work together to do something about it. I'll pass it to Alaina.
Thanks, Vivian. And I think Vivian covered really a lot of the kind of things we were doing. We provide direct services as well. A lot of our clients were in the community rather than in the camps and halls at that time, which we were thankful for, but nonetheless had immediate major concerns, thinking about how they were going to access technology at a basic level, and then all the challenges that came along with that on top of it. So even if you get one computer in a household for a client, what does that mean in a household where there are 5 children and they all need access? thinking about things like that. What about a student who, because of their disability-related needs, isn't able to access instruction via a computer? All of those kind of challenges and individual client concerns that had to be dealt with individually and that schools really weren't equipped to dig into yet. We also did a major scramble to start creating tools and guides and templates for others who weren't represented, so that parents would have resources as they were trying to record what was going on, to request services, to request an IEP, as Vivian was discussing, to discuss this distance learning and how it might work, to record what services the youth was missing or was partially accessing, so that there would be a way to later seek compensation for those services and things like that.
Thanks, panelists. So next we're going to talk about policy and systems responses, and we're going to start with the courts. And so Brooke and Eva will go first, and then juvenile hall and camp conditions work. And so we're going to hear from Victor and Betty in that section. And then we're going to hear about education. So Alaina and Victor will talk there.
So, it's hard to talk about this work, and what I think is so wonderful about this panel is how much we all work together in Los Angeles and across the state. The response to this from advocates was tremendous. We filed with the Pacific Juvenile Defender Center. There was conversation about filing a writ on behalf of all detained youth. It ultimately became from Los Angeles County. And it was a coalition of Patricia Song was the attorney from Children's Defense Fund. Sean Kennedy and I from Loyola worked on the writ. Others from different offices, Marquetta Sims from the Independent Juvenile Defender Panel. There was a writ filed on behalf of all detained youth alleging that they were not being kept safe. We conducted and had our law students, Eva, all of us were conducting extensive interviews with our detained kids. We had kids at that time at several different camps, both juvenile halls and at Dorothy Kirby Center. And we spoke with all of those kids. We created a uniform set of questions and asked them everything from, are there hand sanitizer, masks, what's going on with school, when's the last time you talked to your family? And really, we were asking these questions of them anyway, but we really formalized it and provided declarations in support of the writ. The California Supreme Court granted the writ immediately, directed it to the Court of Appeal. There was ultimately a hearing in April sometime. It's all so hard to recall specifics at this point. It may have been in May. There was a hearing in front of Dependency Court Judge Bianco. He denied ultimately our efforts without holding an evidentiary hearing. So there are ongoing litigation with that. It was a very interesting process, again, incredibly collaborative. In addition to the courts, we tried to, and a number of defense attorneys were speaking regularly with reporters from the LA Times who covered our writ, who covered issues that were going on, who spoke with family members who hadn't seen their kid in a month or 2 months at that point, and really tried to push on an individual level and on a countywide level to advocate for kids in courts across California, any court we could, to release kids from detention.
Thanks, Brooke. So I will say I was incredibly impressed and moved by the response of both the dependency community and the juvenile justice community of advocates. And together, CLC, the Juvenile Law Panel, Loyola, CASA, and other the defense offices came together and really talked about how do we approach, okay, if the writ's denied and we're struggling in individual cases, how do we push these systems with a sense of urgency around how at risk our kids in detention were. And so with the leadership, especially of Jaron Sritsky and Maggie Brandow, we came up with a advocacy letter for the release of dual status youth. It was submitted to probation and all the other heads of county agencies. It called for data on how many dual status youth were detained. It asked for an MDT, a multidisciplinary team process to seek release. And it asked that also probation use discretion around identifying youth who are medically vulnerable for release. So the goal was, how do we create a process to get young people out with plans for either relative placement or suitable placement. And so CLC did a lot of work with DCFS to come up with release plans, because we know that our juvenile justice judges are hesitant to release young people just to DCFS. They want to, a identified safe and appropriate placement. So that dual status advocacy letter led to a motion by the Board of Supervisors that also called for the same goals. And ultimately we engaged in a stakeholder process to create these quick and shortened MDTs. And ultimately that process led to the release of young people. But I will say that the efforts on the defense community and the dependency community were the majority of the releases. Between May and August, about 54 dual status youth were released. At the same time, 44 dual status youth were arrested and detained. And so that process was an effort and a collective joint, push by these advocates. And I think that in hand with the outreach and awareness raising that CLC was doing with DCFS and probation, and that Loyola was doing with the Juvenile Court Health Services and the Department of Public Health, all of those efforts together, I think, push the Board of Supervisors and these different agencies to be more transparent and accountable with data around our crossover young people, and to really try to get our young people out into safer settings.
So Victor or Betty, whoever wants to go first on this.
I can start. Thanks, Megan. And it aligns a lot actually with what Brooke just said. So when the pandemic hit here at the ACLU, our main goal was the same as everyone else's, which was to get as many people out of carceral settings as possible, because as we all know, there's just no way to stop the spread of the virus in those settings. So we filed lawsuits with many partners all across the country to have people immediately released from all sorts of settings, so immigration detention centers, prisons, and juvenile facilities. And here in California, we thought about a case to complement the one that Brooke mentioned earlier, one that we would similarly file in the California Supreme Court, because we thought they were a pretty progressive court and would be receptive to these kinds of issues. And we were really happy that someone was filing a case in LA County, but because there's so many other counties that oversee these facilities, it's essentially impossible, especially in that kind of tight time frame, to file lawsuits in every single one of these counties. And so, we filed this writ of mandate directly to the California Supreme Court to effect change, hopefully across the entire state. It's good because, it can get broad relief potentially, and because really the court has jurisdiction over all the other courts, so they can issue blanket orders. But it's also pretty hard because it's an extraordinarily broad measure that's really only available for really big and important issues. And the California Supreme Court has the discretion to grant it or not, pretty much unfettered, because they're the highest court in the land. And so we did think we had a good shot because of the seriousness of the situation. Obviously, it was one of the most pressing issues that I've seen in my lifetime. And so rather than go county by county, we decided just to take that shot and file the writ. We argued, similar to Brooke and a lot of the other cases we filed, that the Eighth Amendment protects folks from the risk of illness and death by contagious diseases, and it provides the right to have medical needs met while incarcerated. With respect to young people, we argued that keeping youth in isolation and quarantine violated the prohibition on cruel and unusual punishment. And there were a few other kind of constitutional arguments, which I think are fairly logical and sound. Sad to say, though, that our suit wasn't successful either. Actually, we made it even less far than the other suit. The Supreme Court rejected it almost immediately, like within a couple of weeks, and said, we didn't have enough evidence to provide, the court with the description of what was going on in every, all these counties across the state. We did our best, but it was just too overwhelming to do that. And so the court instructed us to file in a specific, within specific counties at a lower court. Kind of a tough pill to swallow because just like the other case, we submitted dozens of declarations from as many facilities as we could, but there's just no way to prove facts in every single one of these counties. And so in hindsight, maybe there just was no way to get statewide relief, even with this kind of progressive court that we had. Subsequently, we filed a lawsuit in Orange County specifically, and did secure a release of 50% of the population there with a standing order until the COVID emergency is over. So that's still in effect, and happy that went through. Orange County Orange County has a lot of incarcerated folks, way too many. And so I think it has had a pretty significant impact. But as I pass it to Betty, I think one lesson that you can all take away from this is potentially litigation is not maybe always the best way to make change. Because even without the court order at the time, particularly in March, April, all these elected officials, pretty much everywhere, California and across the country, were moving really quickly to pass policies doing what these lawsuits were asking. I mean, they were trying to release as many people as possible just from political pressure. And so another strategy that we and our partners kind of pursued was to try to send letters and give public comment at every level, from the governor to the legislature to the county board of supervisors, to just ask them to release as many people as possible and to provide recommendations about how they can do that. So they did that. And here in LA County, they released lots of folks, folks who were medically fragile, people who were incarcerated waiting for trial, people convicted of low-level things, people with a release date that was close. And the populations did fall pretty dramatically. Sad to say, they are rising again, I think, with a loss of a little bit of momentum. And I'll just, before I pass it to Betty, I'll just say it's kind of perverse that they can just snap their fingers and let so many folks out of these jails and prisons, because it really makes you question why they were incarcerated in the first place. And so I think it's just kind of evidence that the system really is broken, and hopefully we don't just go back to business as usual from before and kind of learn a lot of lessons of get some silver linings from this terrible pandemic. And so as part of our advocacy, we and pretty much all the organizations on this panel sent a letter to Laker on probation asking them to prioritize education and to, for the folks who weren't let out, make sure that they at least are receiving PPE, like having safe conditions and receiving the education that they deserve. And so I'll pass it off to Betty to talk about this really kind of long-standing campaign that we've been running since then to try to improve education for the folks who remain.
Thanks, Victor. So as he alluded to, a lot of political pressure was necessary and also helpful during this time. The first couple of weeks after school closures was a very chaotic and hectic time across the state, across the country. And what we found was that, in addition to having legal strategies, other strategies that would invite elected officials or system officials into the conversation was also really helpful. And Youth Justice Coalition was a major part of organizing over 4 town halls in the very beginning of the pandemic to invite system officials to hear the concerns of community members, students, and families. And it was an opportunity for, the Office of Youth Development Diversion, Los Angeles County Office of Education, or even probation department officials to come to the table and respond to the urgent demands and needs that young people and community members were expressing. And while the first, town hall was on March 25th, they were held over the series of a couple of months. And each time was an opportunity to go deeper on issues and to continue inviting more and more people to the table. I will note that I believe a lot of invitations were extended to folks, including people in the courts, and judges were included. And I don't think if my memory is correct, that judges did come to any of the town halls. So there were still challenges with who we were able to have access to and who we could get to take part in these conversations. And additional efforts were also necessary to push for support either from the Board of Supervisors or even for the Los Angeles County Office of Education to support the release of young people. Efforts included like car canvassing and protesting in downtown LA, and organizations were very creative in finding ways to escalate and bring attention to this issue, as so many issues were urgent during that time. Those methods of organizing are still incredibly important and powerful during these times. And because of those efforts, the Los Angeles County Office of Education was also on board eventually to issue a statement supporting publicly, the release of young people as much as possible, understanding that, they didn't have direct control over the release of young people. They were still responsible for the care and well-being of students that they're educating. And so it only made sense for them to stand in support of young people's health overall. What's a little bit different about CDF is for us, we have several policy teams, and we have, people who work on health policy, education, youth justice, and Brooke mentioned earlier that people in the youth justice team at our organization focus on some different legal strategies. And for the education team, our expertise and experience lies in school board advocacy. So during COVID-19, when a lot of organizations came together to address these issues of education in the halls and camps, one of the initial strategies we used was the school board level advocacy. And the situation at the time was incredibly disheartening. We were able to see that LACO's specialized high schools, for students who are incarcerated, students were transitioning to virtual instruction within a week of school closures. And in the meantime, we were hearing about young people in the halls and camps just getting packets for weeks on end. And following the letter that we sent to LACO, we were able to have some staff meetings with them to understand and ask, what the plan was to transition to virtual instruction, how long that would take. But the progress that was made, I think, really wasn't possible without so many organizations and so much attention placed on this education or placed on the school district that normally doesn't get a lot of scrutiny. It took months for virtual instruction to begin to be rolled out at the halls and camps. This had to be done site by site. If you just ask the school district what their virtual education plan was, they would tell you, oh, it's in progress and things are happening. But we knew from, working with Megan and Vivian that there are clients who are at sites who are not getting any virtual instruction, despite us being told publicly that virtual instruction was happening. So it was necessary to do very specific follow-up with staff. And due to, I think, ongoing challenges with just ensuring there was connectivity, there was sufficient devices, we continued to escalate. And that led to us doing a lot more directed advocacy at school board meetings where we would show up and provide public comment. And key to this sort of longstanding school board advocacy effort were young people at organizations like the Arts for Healing and Justice Network and Youth Justice Coalition. So earlier, I know during the break, there was a poem by a young person named Maura. And Maura was one of the youth who actually analyzed LACO's budget, the Learning Continuity and Attendance Plan, that all school districts in California had to fill out and document what their plans were for spending during COVID-19, how they were going to measure learning loss, and what intervention strategies they were going to use to make up for students' loss of instruction during this time. So Maura, Black, Minor, and Justice, and Kevin were all young people or formerly system impacted students who looked at budgets with us, who attended different meetings with us, and tried to, give meaningful recommendations that went beyond compliance as well, to actually assert what a vision of education needed to be for young people that was meaningful and substantive. Our school board advocacy included kind of normal things like trying to improve their their distance learning plan policy to address issues that we were seeing in the implementation of things, as well as other ways to improve data reporting on special education access, transitions for young people enrolling out, leaving the halls and camps and when they're enrolling in school. And I think over the course of many months, many arduous months of trying to improve data reporting and transparency, we also found that there was really little accountability for juvenile court schools. And we knew this before the pandemic, but it was so much more apparent during COVID-19 when there was additional attention paid to the needs of marginalized students, that this specific set of students in these environments were not being thought of at all when people were talking about the digital divide. And our organizations, did a lot of advocacy with the school board, and still, because of challenges that we encountered, we kept escalating. We tried to send letters to the California Department of Education and the California Superintendent of Instruction to intervene, and eventually we went to the County Board of Supervisors. So it has been a very long, arduous journey. And I think to kind of summarize and wrap up before I pass it on, what is unique about LACO is that it's a school district, one of the very few, perhaps I think the only in California, where the Board of Supervisors appoints both the superintendent and the entire board. So this is different from all other school districts, which normally have elected school board members or an elected superintendent. And that has been one of the reasons why it has been hard to make changes and advocate for change. And so change required a county level supervisor strategy. And after doing a lot of education with Board of Supervisors offices or Justice Deputy staff, they were better able to understand what was going on. And at the same time, the county level officials aren't used to thinking about education because normally that's the jurisdiction of school districts. So it was an unusual situation, but we are really grateful that a lot of supervisors' offices did care. And we're happy to say that, even as of yesterday, the Probation Oversight Commission did take these issues to heart and decide to create a standing committee on education to oversee specifically these issues.
Thanks, everyone. So Alaina, did you have anything else to add about initial responses to the pandemic?
I can just add briefly that there was also, in the work of this coalition and all of these advocates coming together, there was also the work of several letters that were written to try to influence those in positions of power. So, for example, the Department of Education, as they were receiving federal money, how they should distribute that and how that could most impact the youth that we were working with, and seeing the need for addressing laws that came out and how they might be being misinterpreted at the school district level, and guidance that would be helpful in making sure that youth's needs were met. So that was just another form of advocacy that all of us folks were working on.
Thanks. So next we're going to talk about I think we talked about the initial responses, but we're going to talk about now kind of ongoing concerns. So now that we're basically, yesterday was like the 1-year anniversary, right? So we're 1 year into the COVID-19 crisis. What are your ongoing concerns about how the needs of system-involved youth have been met and are being met during this crisis? What are your concerns today? So we can start with, why don't you just jump in if you want to say something?
I'll say what aren't my concerns. I think that I think Victor sort of alluded to this, but we're kind of back to business as usual. We have a new normal, which is WebEx court hearings, at least from the delinquency side, right? We have WebEx court hearings. Kids aren't transported to court anymore unless it's a very significant hearing or an admission or an actual trial or contested hearing. And I have concerns about their ability to understand what's going on in court. It's very difficult for kids to understand what's going on in court when you're sitting right next to your client without a mask on and you're able to talk to them. You're adding barriers of distance. There's no privacy when you're, talking, if your client needs to ask you a question. I don't think that the services are back up and running in a way that are appropriate for our kids. I understand that from a health perspective, we're still dealing with this ongoing crisis. And then there are a lot of safety concerns that the systems have to balance in thinking about safety of staff and kids and all of that. But I worry about isolation. There are quarantines all the time still, particularly when we were in our last surge. Again, the LA Times covered this, but our kids were getting COVID and being quarantined and in quarantine after quarantine after quarantine because it would be a new outbreak. And I had kids that appeared on the phone, didn't even get to appear on WebEx because they were in quarantine because of exposure, not because they actually had it, but because they were exposed by others. And that means that parents can't come visit when kids are in quarantine. So it's just still an ongoing, crisis, although it seems as though the urgency has backed off a little bit. And I'm not sure that that's actually accurate.
Yeah, I'll also add in the school context, students are still struggling. It's been a year of really inconsistent learning, if there's learning at all. And, for a lot of our students, and Alaina alluded to this earlier, is that if they can't access the technology, they can't access learning at all right now. So I have a client who really never grew up with technology in the home, doesn't know how to access it in order to access his classes. He really needs in-person services, but the district hasn't been able to provide in-person services to any student. And so we actually filed a compliance complaint to the California Department of Education in order to provide in-person services for the student. And still the district isn't providing those in-person services due to health concerns. And so even though this pandemic is very real and we certainly don't want to put anyone in danger, and especially we don't want to put our client in danger either. But it speaks to just how important those in-person services are for this particular client to access his education. The other concern I have is that, because you have a year long of inconsistent and inappropriate instruction, a lot of our students are extremely disengaged, especially the older students. So we represent, the majority of our clients are actually older teenagers, older than 16 years old. And so for the students who are 17, 18, who just need a few more credits to graduate, but are really disengaged from school, who have been disengaged even prior to the pandemic, they are at risk of dropping out at the very last hour. And so it is really disheartening for us because we can see that the pandemic has really set those young people back. So more and more we are even entertaining the idea of independent study programs, some more flexible educational programs for those clients who really can't engage with the 4 to 6 hours of virtual instruction per day. So that's pretty unprecedented for us as a legal practice, but we really are trying to advocate for what our client wants, which is to graduate at all costs. So I will say that it is really hard to engage our older youth right now.
also add that on the dependency side, the pandemic and the shutdown of the court, besides for detention hearings or essential hearings initially, contributed to a backlog of dependency cases, and there was actually an increase in supervision by DCFS over young people. And so I know that CLC has been advocating and including continuing dependency funding or funding for dependency counsel at the same level as prior, so that we can move these cases along. But the limits on visitation obviously affected the relationships between our youth and their families, and the lack of pro-social activities, the lack of access to young people in group homes by their support teams, having all the RAP teams be virtual. All of these things connect to both the therapeutic healing of our youth, but also the compliance with conditions of probation. And so, as I said before, this has led to advocacy in delinquency court around being flexible and compassionate and creative and getting our judges to come up with other solutions. And I'm hopeful that, those routes continue and that our courts recognize that there are already existing barriers to engagement, and those were only further heightened with the pandemic. I will also say that the pandemic caused the shutdown of the 241.1 dual status court, which was where dependency and delinquency cases were heard in the same courtroom. That was a small pilot project, but I think it was important to pushing the innovation in this, specific niche of legal services. So I'm worried, what will happen next with that. And then similarly, the 241.1 protocol reform process has been put on pause. And obviously that protocol is so important to how these cases are litigated and to the outcomes of dual status youth. So I know that advocates will come together to continue to push that process, but clearly the pandemic has, caused a lot of things to be put on hold for specifically crossover youth.
Great, thank you, everyone. So with our last question, let's talk about the long-term impacts of COVID-19 and the systemic inequities highlighted. So this has been something y'all kind of touched on so far, but I really want to focus on, what are your concerns moving forward from here? So we can, just have anybody jump in that wants to on this question as well.
I can kick it off. Like Brooke and others said, it's just so overwhelming. We could go on for hours about all the different problems. I'll just focus on a few narrow ones that are just coming across our desks right now. One is, and building on what Vivian said, it's a real challenge to address learning loss, because you first have to assess it. It's clearly happened for every student across the state, no matter where they are. But you have to figure out how much has happened. And I think there's a real debate amongst students and parents and advocates right now about how to do that and whether to do that. Because on the one hand, you need to figure out where they are right now to be able to provide the services to catch them up. But at the same time, a lot of families see it as stigmatizing if they have to go in there and take a test for which they are not prepared. They don't want to get an F and get that mark on their grade that potentially will foreclose future opportunities. So I don't have an answer for that, but I think people are really struggling with how to do that and how to essentially make students whole and provide compensatory services for everything that they've lost in the last year. I'll throw out a couple other just really narrow ones that we're thinking about that are fairly unique. Tech privacy during distance learning, because we've all moved there now. And very few people are thinking about it, but it's been a real pervasive issue over the past few months and will continue to be. Like, for example, a lot of school districts and companies are requiring families to provide social security numbers, IDs, like passports, things like that, just to borrow equipment or get access to the internet or technology. Like when they sign up for ISPs, they ask for really intrusive information. And so they either have to disclose all that stuff, which violates their privacy and potentially even reveals certain immigration information, or just not have access to education. Other stuff that is just really, I think, harmful is like software that blocks certain subjects, because school's now all through these computers, but like we've seen software blocking topics like Planned Parenthood or Black Lives Matter or even the word abortion. And I think, I mean, that is clearly unconstitutional and violates students' First Amendment rights. But we're seeing that all across the state right now. Then we're also seeing software that tracks students' emails and social media, catching keywords and providing supposedly interventions, but really we see potentially law enforcement if they see words like gang or drugs or things like that, just in students' daily conversations. And we know how students talk generally with their friends. And so we're just seeing a lot of like issues beyond even the distance learning, and digital divide issues that everyone's discussing that I think will take years to unravel. But I guess we're closing. So my closing thought is just that I'm very grateful to be in a community with all these folks here in this panel and outside the panel to work on these issues, because it's very overwhelming, but it gives me some comfort to know that there's a lot of really talented and committed people working on this.
Agreed, Victor. And I'll jump in after you. One thing that we're really concerned about is all those youth who have had IEPs that have changed to respond to the crisis. So for example, maybe had, a ton of services when they were in school and needed that support. Now, while they're at home, they've reduced that support significantly because they didn't need it or because it wasn't able to be provided. For youth that don't have a, sophisticated with the system caregiver or education rights holder who's able to jump in and make sure that their IEP gets changed before or shortly after they re-enter the school system, they're really potentially being set up for serious failure without a significant portion of their services. And that, leads to school discipline issues, all of those kinds of challenges. Another thing that we're thinking about is as school districts have responded to the crisis, are there potential positives? So as they're rewriting, for example, enrollment policies, because they couldn't have their normal policy of requiring someone to come in and they're creating a digital policy, is it an inclusive policy? Does it allow for mobile options rather than needing, a laptop? Does it allow for all different types of folks and support for completing those things and language services? As we're rewriting systems, as we're changing systems, are we keeping, these causes of equity in mind? And for things like school of origin, where that has actually improved for a lot of youth during the pandemic, a lot of youth, it has now become, as it was before, it was hard to keep a youth in their school of origin because it required setting up transportation and addressing that. Now that's kind of become the easier option because the youth can keep their technology. We don't have to make those transfers when a youth moves. So a lot more youth are staying in their school of origin. How do we make sure that we capitalize on that as we go back, that we keep youth accessing those few bright lights that we have seen during this time?
I'll say really briefly on a sort of positive note. It's hard to talk about the pandemic without talking about George Floyd and the protests this summer. And I think what these two things have done have really blown the lid off of a lot of these systems inequities, both in Los Angeles County. We've seen incredible student leadership. I think it's the LA Deserves campaign and trying to defund LAUSD school police. And that's a youth-led movement. We have seen, and a lot of people, I think, are more keyed into these issues than they ever were before because people were home and they started reading and they were horrified and they started protesting. And, I'm hopeful that we can continue this sort of greater community conversation and bring in people from all places. I think all parents in Los Angeles County should think about, okay, what if there's another pandemic and my child is locked up away from me and I cannot get them, I can't get them home. I have no power to get them home. Parents, I think now are going to think about like, wow, my kid has been home for a year and it has been so stressful on so many different levels. And I just think, my hope is that we can continue to grow and evolve, all of us, and have more real conversations about race and about inequity.
I would just add that as a result of the Board of Supervisors motion around the release of dual status youth, some of those clear inequities were brought to the surface. And so data around dual status youth really showed that, numbers that we already know and inequities that we already know, but that the majority of youth, dual status youth that were detained were African American and Latino, and that the majority of there's high numbers of dual status youth in Dorothy Kirby Center, which I think is really important for us to think about the intersection of trauma and mental health and race and how normal behavior, normal responses to trauma and normal adolescent behaviors are criminalized. And so I agree that, both the pandemic and the protests have really brought to light and I think increased commitments around reducing disproportionality in the dependency system and specifically for crossover youth.
Vivian or Betty, anything to add on this question?
Yeah, I mean, trying to stay on the positive side as well, I think what the pandemic did was really put a spotlight on all of the inequities that have long existed, right? In the juvenile detention facilities, education was almost always bad. The students there were always being relegated to independent packet work, at the very mention of a riot, and they would be, probation would refuse to escort them to the classrooms on a regular basis. And so, there was always interference with the education of detained youth. And what the pandemic did was really put a spotlight on that. Even before the pandemic, we knew that the living units weren't even wired. And we knew they weren't ready for virtual instruction. And so with the pandemic, a lot more people learned that. And together we advocated and pushed LACO to actually wire those units. So there has been some positive benefits to this year of advocacy for sure.
To build off Vivian, I think we saw some temporary solutions during COVID-19 to some longstanding issues, but we know that they will also not solve underlying problems once COVID-19 is over and there's a return back to in-person instruction. So education quality, I think, is still very important to focus on even after there's a return. Students like Kevin and Mina reminded me, yesterday in their testimony that the curriculum that they're provided, may not be A through G compliant. There are students who receive the same types of materials or enrolled in the same classes, no matter what grade they're in. And those are issues that are going to remain regardless of whether students are in virtual instruction or in-person instruction. And second, Victor alluded to earlier, the need to examine our systems and why young people or adults are in the system to begin with. And there was progress made, I think, in ensuring that as many young people could be released as possible. But it will also be important to think about how do you maintain the reduction of young people inside and ensure that the numbers don't just increase over time.
Any other final thoughts on this question from our panelists? We have 2 more minutes.
I'll just add one more quick issue that I know a lot of us are dealing with, which is school discipline, both now during distance learning and when students return to schools. Just to tell a few anecdotes, we're seeing students, a student had the police called on them for having a BB gun in the background of a Zoom class. We're seeing students being shut out of Zoom classes because they're quote unquote being disruptive when they could really just be muted if that was the issue. We're seeing students who are getting disciplined for violating certain social distancing or mask protocols during hybrid learning. And so there's just so many issues that are bubbling up that are just completely brand new that nobody knows how to address, that we are starting to see that will only become amplified as more and more schools come back into in-person instruction. So again, no easy answers there, but I do think we will be at the forefront of trying our best to protect the students who are impacted.
Thanks, Victor. Anyone else? Final thoughts? All right, I'll turn it back over to Sean Kennedy. Thanks everyone for participating in this panel and for all the work you've done during COVID-19 and beyond.
Thanks for the great panel, Megan. We're going to take a 10-minute break again, and then we'll return with our last sessions, lessons learned from the field and looking forward. So we'll see you at our last panel at 11.